One of the prevailing myths on YouTube is that a cop is not a cop if he fails to act upon his oath. Others claim it's the warrant card that establishes a policeman's powers, or the wearing of a uniform, or even the putting on of a hat. So if we combine all these arguments, the ultimate question would be, is a police officer without uniform, hat, warrant card and off-duty still entitled to use his powers of office? The answer, surprisingly, is yes, because it's none of those things that define what is or isn't a constable. For a constable to legally enjoy the powers of office, he must meet the following conditions: to have undergone the necessary training, to be deemed suitable to hold the office of constable, to have sworn an oath, to be currently employed by the police service, to be acting within the execution of his duty. The most notable of these isn't swearing an oath, but acting within the execution of his duty, which I'll come to in a minute. In short, as long as a constable is employed by a recognised force and is acting on their behalf and in accordance with his duties, he has the powers of office, on or off duty, in or out of uniform, with or without his warrant card. However, any officer who's suspended from duty, dismissed, retired, or has otherwise left the force forfeits all associated powers. They become ordinary citizens just like the rest of us. And this suspension of powers can occur even when an officer is on duty in full uniform. How? Because a constable who acts outside the execution of his duties technically ceases to be a police officer, at least until he begins acting within the execution of his duties again, which could be a lapse of just a few seconds to maybe a few hours. For instance, a cop fast asleep in his patrol car cannot be said to be acting in the execution of his duties, nor would an officer sat in a bar, drinking, or roughing up a prisoner in the back of a van. The same goes for any other act they engage in that falls outside of their duties, such as reckless driving, misuse of force, trespass, or flashing the warrant card at the neighbours when they won't keep the noise down. This is most significant in cases involving prosecutions for assaulting a police officer in the execution of his duty, because if it can be shown that the officer was not acting within the execution of his duty when the alleged assault took place, then the defendant must be acquitted. A good example of this would be a policeman who stops someone in the street and won't let them go until they've answered questions. A common theme on this channel. Nobody's obliged to account for their lawful activities, and nor can the police detain people for questioning short of arrest. So, if you choose to walk away and the officer obstructs you, then you can use reasonable force to clear your path. What is reasonable depends upon the circumstances, but what is most important is if you can prove the officer was not acting within the execution of his duty when you assaulted him, then the offence cannot be made out. Recently, the press and the government have been touting figures that give the impression that assaults on the police are rising, but what they don't tell you is that assault is not confined to physical violence. Instead, assault is defined as when a person intentionally or recklessly causes another to apprehend the immediate infliction of unlawful force. This means that simply threatening a police officer can be classed as assault, as can pushing, resisting, or even implying the threat of violence. And it is this low threshold that explains the relatively high number of prosecutions for assaults on officers, the vast majority of which involve no actual physical attack on them by way of cuts or bruises, because if it did, the police would opt for charging under the more serious offence of actual bodily harm. Unless, of course, you believe the police are quite happy to downgrade attacks upon them in the hope the courts will go easy on their attackers. I don't think so, because not only is assaulting a police officer in the execution of his duty a lesser summary offence, it's also notorious for being successfully appealed against on the grounds that the officer was not acting in the execution of his duty at the time. Unfortunately, due to the overinflated figures of alleged assaults against officers, the government has now seen fit to introduce the Assaults on Emergency Workers Act. Now, merely pushing or shoving, or even attempting to resist the police, could land you with a 12-month prison sentence. Even spitting at the ground in front of a police officer is defined as assault. To make matters worse, the Act drops the use of the term acting in the execution of his duty and opts instead for the vaguer term of acting in the exercise of functions as an emergency worker. The CPS have already advised prosecutors to ignore the lesser charge under the old Act and opt for the harsher charge under the newer Act, despite assaulting a police officer in the execution of his duty never being repealed. There's two reasons that this potentially spells trouble for the public. Firstly, if if you know anything about civil lawsuits and the police complaints process, you'll know that the police are very good at covering their arses. When faced with a complaint that unnecessary force was used against a detainee, officers will often allege that the force was necessary because the detainee assaulted them, even though the detainee never laid a finger on them. And once they speak this lie, they are happy to back it up with a prosecution for this non-existent assault. To the police, losing your liberty for something you didn't do is a small sacrifice to protect them from losing their jobs. Secondly, by abandoning the lesser offence of assaulting a police officer in the execution of his duty, it also abandons the volume of case law that goes with it, which means anyone prosecuted for the newer offence of assaulting a police officer acting in the exercise of functions as an emergency worker might find, to their horror, it's now a strict liability offence. In other words, there is no available defence. So even if you are acting in self-defence against an unlawful arrest, the courts might still find you guilty of assault under the new offence. If this were the case, then this would ultimately mean that you couldn't use any kind of resistance or self-defence to protect yourself against lawless police officers. I'm hoping that this isn't the case and that we soon discover that the new definition carries with it the same body of law as the older definition. But unfortunately, the problem with any new laws aimed at helping the police is that they quickly find a way of using them to punish the public instead.